Hey everybody, this is Cleveland's disability lawyer Michael Einer, back with another video from our web series about the interplay between Social Security, disability, and other practice areas. Today I'm excited. We've got an excellent guest. We're going to be talking about the interplay between Social Security, disability benefits, and bankruptcy law. And here I've got with me today Heather Moseman from the Moseman Law Firm in Mentor, Ohio. Heather, why don't you tell the viewers a little bit about yourself and your practice?
Thanks, Michael. Moseman Law has been in practice for 14 years. We've been practicing bankruptcy law that entire time. While bankruptcy seems very straightforward, there can be lots of nuances that can help or trap some of our clients. So we're going to talk a little bit about how to avoid those traps today.
Yeah, I'm very excited because in our office we get a lot of questions about bankruptcy. As I'm sure you can imagine, Social Security is a long and challenging process. The average case takes about 2 years, but sometimes if we end up having to go to the appeals council and federal court, it can take our clients 4 or 5 years to get approved for benefits. During that time, their bills, fall by the wayside. And so we get a lot of questions from clients that they're thinking about filing for bankruptcy. So I'm excited to hear a little bit about things from you this morning. Let me ask you first of all, when there's different types of payments that people receive. There's different types of disability benefits. First question: does it matter whether somebody, if they're looking into filing for bankruptcy, is receiving or applying for either SSD or SSI?
No, in bankruptcy they treat Social Security benefits the same, and all of them are exempt from being counted toward your criteria for filing a 7 versus a 13, which we'll talk about in a minute. And they're also exempt from your creditors and or the court taking that money and using it to pay your creditors.
And you started bringing something up that's important. There's different types of bankruptcy that individuals can file for.
Yes.
I think you said Chapter 7 and Chapter 13.
Yes, those are the two types of individual bankruptcies, which are most important to our viewers today. Chapter 7 bankruptcy is what we call a liquidation bankruptcy. So any of your assets that are not protected by the Ohio exemption laws, or certain laws that say so much equity in your house or your car or your bank account is exempt from being used by your creditors for anything. But let's say that you have an asset that's worth more than that. That extra value can be used to pay your creditors through the bankruptcy court. So when we look at the difference between a 7 and a 13, a Chapter 13 is more like a court-ordered credit counseling program. Okay. So you will keep your assets, you just have to pay the value of that extra into what we call a Chapter 13 plan if you were to go Chapter 13. They're also income-based. If you are at or below the median income for your family size, it's presumed that you can file a Chapter 7, all other things being equal. If you're over that, it's presumed that you need to file a Chapter 13 because you have some money to pay your creditors. When we are looking at Social Security benefits, those benefits or those payments are exempt from being counted in what we call your means test income. So you could make a little bit more with your Social Security benefits, and if you're still working part-time or if you have another pension or something like that, we just have to adjust for it in your monthly expenses. So Social Security benefits are actually a good thing in qualifying for bankruptcy.
Okay. That's interesting you said that. Does a court consider more favorably somebody, if they're going to approve the bankruptcy application, bankruptcy filing? Mm-hmm. When you say that it's favorable,
it's favorable in the way that you would qualify for a 7, whereas you might not a 13. So let's say that you're getting disability benefits and they're $1,200 a month.
Okay.
Let's say that you have a pension either from the state of Ohio or a private entity or something like that. And that pension payment is, let's say, $2,000 a month. So technically you're bringing in 32, I think I said $1,200 a month. So you're bringing in $3,200, which may push you over the income threshold for your family size if Social Security income was counted in your monthly income to qualify. Now, we still have to account for it in your monthly income versus expenses, but whereas that income may have pushed you into a 13 if it was other than Social Security income, it allows you to do a 7, which can get rid of some of those medical bills, some of the credit cards that have had to live on while you're waiting for those benefits to come through.
It's very interesting. Now, one thing that I know we've talked about and I've learned about is the importance of not commingling funds.
Yes.
And you were in the example you gave, you were talking about income coming from a couple different sources. So can you talk about the
about how to protect your Social Security?
Yeah, please.
Social Security income, whether it's monthly payments or a lump sum, is exempt from your creditors in a bankruptcy court, unless that money is mingled with non-exempt funds, meaning regular payments, whether it's from work, whether it's workers' comp, whether it's some sort of private disability, anything like that. So let's say that you are getting, again, back to your example, $1,200, a month in Social Security, and we have that $2,000 in pension. What you want to do is make sure that the Social Security is direct deposited into its own account. You can then transfer that money and use it to pay your bills. So let's say that we have one account for Social Security, and then we have the other, basically your family's operating account. So that $2,000 goes into the operating account, your $1,200 goes into the Social Security account. As long as money only goes from the Social Security account to your family operating account, the money that's sitting here is exempt. It's sitting here in the Social Security account. The minute you take money from the family operating account and put it into the Social Security account, now that money is no longer exempt and it is subject to your creditors.
Okay, that's good to know, especially for a lot of our clients where maybe one spouse is receiving Social Security and the other is working.
Right.
It's good to know that those Social Security funds are protected.
And you want, if I may interrupt, you want to be sure that if you're getting a lump sum payment at the end of your waiting period to get your claim approved, you want to make sure that that lump sum goes into its own account. It's the best way to start with Social Security. If we are contemplating bankruptcy, all that money just sits there, and you could have $30,000 in that account, and you can still file bankruptcy and keep all that money as long as you've never commingled it.
One thing that I think people might be wondering about is the timing of things. If somebody is applying for, maybe they haven't been granted disability yet, or maybe even if they already are receiving a disability benefit, is there a right time or a time that's too early or too late to consider filing for bankruptcy?
No. Because Social Security is an exempt benefit, you can file, you can be in the middle of filing, you can be at the end of filing, you can start applying while you're in a 13, although if you file and get benefits while you're in a 13, that's counted as an increase in your income and your plan payment may go up, but now we're getting really deep into bankruptcy.
Okay.
But no, you can file whenever you want to. There is no stay. Normally there's an automatic stay for cases. In the case of Social Security, there isn't, so you can file whenever you want. I usually suggest to my clients who are applying for Social Security is to wait as long as you can, so that if you're still getting medical bills or you're having to live off your credit cards, that we can get rid of that at the end, so that we don't get rid of half of it and then you're stuck, because you can only file a Chapter 7 bankruptcy every 8 years.
Okay.
You can file a Chapter 13 as often as you want to. You can only get a discharge every 4 years in between. But let's say that you get hurt today and you don't have the right insurance, you're whatever it is, and your family has to live off your credit cards. If we file today everything that comes after that, you're stuck with for at least 8 years.
Okay. I think that you've answered the big questions that I hear regarding bankruptcy filing for my disability clients. I want to thank you so much for coming and talking to me. We're actually here on location today. We decided to do this in an exciting place. We're actually at the U.S. Bankruptcy Court here in Cleveland, in their attorney meeting room. I really appreciate you coming. Can you just tell people how can they get a hold of you if they have questions about bankruptcy and they decide they want to speak to a professional?
Sure. Our firm is called the Moseman Law Office. We are in Mentor, Ohio. You can reach us by phone at 440-255-0832, or you can reach me via email at heather@mosemanlaw.com.
Great. Thank you so much, Heather.
Thank
I
you.
appreciate you coming today.
Finally, girl, the disability warriors, fighting for those who cannot fight for themselves.